The final matter to come before the court this morning is State of Ohio versus Kenneth Carney. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve time for rebuttal, if you'll let me know when you get started. I'm keeping the clock this morning and let you know about the passage of time and the time remaining for rebuttal. The court's read the briefs. We're ready to proceed when you are.
Thank you, Your Honors. I'm attorney R.J. Budway. Good afternoon. Representing the appellant. We filed an appeal of a sentence from the trial court for one count of a misdemeanor of third degree. The charge was criminal damaging. As the court's aware, originally this was a domestic violence misdemeanor of the first degree, and there was a plea bargain struck whereby Mr. Carney would plead the misdemeanor of third degree. Mr. Carney was sentenced to 60 days jail with 30 suspended, got 4 days credit for time served. He was placed on a 5-year term of intense supervised probation, 5 years of monitored time. While on that monitored time, he was to be hooked up to an alcohol monitor. Up until the date of sentencing, Mr. Carney had been on an alcohol monitor and had no violations. We believe that this sentence is excessive for the level of misdemeanor. We believe that the trial court did not look at all the overriding principles and purposes of misdemeanor sentencing. At the sentencing hearing, counsel for Mr. Carney had pointed out the number of positive counseling sessions and things he had done prior to the sentencing date. Attending 4 AA meetings a week, he had no positive tests. While on an alcohol monitor, he had treated with a Dr. Ray successfully. He had also treated at LACATA, the Lorain County Alcohol Drug Abuse Services. He was also made a chairman, sponsor there. He also joined Mothers Against Drunk Driving. He had not had any convictions in 8 years, and he only had one violent conviction, actually one criminal conviction in his lifetime, which is an attempted assault. Even with all of that evidence, the court gave him a harsh sentence for misdemeanor of third degree. In looking at like sentences, which in the appellant's initial brief, we did not provide any citations to similar sentences, but we did in our SIR reply. We looked at 60 cases. We looked at 11. We looked at 60 consecutive cases. We found 11 cases that were misdemeanors of the fourth degree, third degree, or second degree, including one criminal mischief, and found that in every case the court always suspended the jail time and fined the defendant.
Were you isolating those cases that had been pleaded from a greater level to the M3? Were you taking that into consideration?
I'm sorry, taking what into consideration?
Well, in this case, your client ended up pleading to an M3. When you went through and in your brief you cited this number of cases, they were all sentences for an M3. But did you take into consideration whether any of those cases had been amended from an M1 to an M3? Or might they all have simply been charged as an M3 initially?
Your Honor, I did not take that into consideration when I did that. I simply took a 60-case sample of the docket, and the docket is tens of thousands of cases, and just went through and looked at those like, I guess I could have cherry-picked where I wanted to start, but I just took in my mind, a random sample of 60 cases. And in all the cases that were similar in magnitude and sentencing, everybody, or all the defendants were given suspended jail time. In this particular case too, Mr. Carney was placed on an alcohol monitor for 5 years. Again, without having provided an affidavit of the cost, I know some of this panel has worked in the municipal court before. These monitors are very expensive, and again, Mr. Carney would argue that being placed on an alcohol monitor for 5 years out of misdemeanor of the third degree is excessive and abuse of discretion. The court, even though it did not enumerate the factors on the record, it did look at his record. The court, this sentencing entry, focused on the plea bargain that was struck. I would indicate to the court, by just looking at the cases in my reply, the sentencing entries are very short. This was a 17-page sentence that was crafted specifically for Mr. Carney. One of the objections made by Mr. Bradley on the record was that the court had pre-prepared this entry. It was a very lengthy entry that's not normally used, that isn't used by this court, in preparation to obviously give Mr. Carney a severe sentence. That again, we feel is excessive for that level of misdemeanor.
He is a public official.
That is correct, Your Honor.
And there's going to be some scrutiny of this because of his position, right?
Without question, Your Honor. And we,
Do you think that might have played into the trial court's decision to be thorough in doing this?
well, Your Honor, I would never want to speculate to what the judge was thinking, but I can speculate that we believe that that was a factor for a 17-page sentencing entry.
Well, but I guess the question is, coming from this court, do we want to send a signal to trial court judges that if you take the time to write, a thoughtful, sentencing entry that takes into consideration the law and, past all of the guidelines and the things that the factors that the legislature says you ought to pay attention to, that we're going to punish you because, you did that.
No, we don't. I think every defendant should be treated the same. Now, as the court's aware, there are offenses that involve public officials where a public official could be identified, but then again, they're also punished for being a public official within that statute.
He was charged with a first-degree misdemeanor, domestic violence, right?
Correct.
That's what the charge was.
Correct.
And the consequences of that are way outweigh a third-degree criminal mischief, or what was it? Mischief.
Criminal mischief here.
Consequences. The point I'm trying to make, it just seems that the allegations in the complaint way outweighed what he ended up with. So there was a plea here.
There was a plea to a lesser charge, but I submit to you that we believe the penalties imposed were the stiffest penalties you could possibly get for such a mid-range misdemeanor.
But the facts of each case are different, though.
Absolutely, Your Honor.
So how can you treat them all the same when the facts of each case are different?
You can. In fact, I believe there's case law that courts should not have a policy as to sentencing just for consistent sentences. I didn't cite those cases in my brief, but I'm familiar with the case law.
So what are we going to find in the record with respect to the sentencing entry? I got the flavor from the appellant's brief that there was no dialogue, that it was that the defendant and counsel were given a chance to indicate what some of the positive things that have happened did occur, and then the trial court read its prepared judgment entry, or was there some sort of discussion? What are we going to find in the sentencing hearing transcript?
Your Honor, in reading the transcript, most of the transcript is the court addressing Mr. Carney about the history of the case, the history of the charges, the amendments. The court does address that he has the prior offenses, which I believe total 5, 3 are traffic, 2 are criminal, 1's a minor misdemeanor. And every case involves alcohol. After that, the court focuses on the fact that he needs to get a more severe penalty so he doesn't reoffend in the future. But absent that, the court doesn't address any of those issues, in my opinion. And of course, the appellant was offered a chance to offer mitigating factors. And as I indicated in my opening, at the opening of my statement, there were numerous mitigating factors in his favor. That he, went to treatment programs. It did the things that the court should have considered mitigating, especially, again, with a lower level misdemeanor like this.
So he was sentenced to 60 days in jail, and then, am I correct, that 30 days was suspended?
Yes, Your Honor, he was sentenced to 60 days in jail, 30 were suspended, he got a 4-day credit for time served, gave 26 to be served. He received a maximum fine of $500, 5 years of intense supervised probation, 5 years on alcohol monitor.
So I just understood you to say, and I did read this in the brief, that the court, among other things, looked at his prior record and noted that every one of his offenses involved alcohol. So the court said, you know, I want to keep this time over your head. I'm not going to have you serve all this time now, but I want to use this, keep it suspended, but I want you to remain on this alcohol monitoring. So you're arguing that even though all of his offenses involved alcohol, that somehow the court abused its discretion in having him remain on monitoring.
I am arguing that, Your Honor. Now, whether that's persuasive on this court, I don't know, but I guess I am arguing that because of the level, it's a misdemeanor third degree, to be given the maximum sanctions allowable for misdemeanors.
But he wasn't.
He wasn't.
He was given basically 30 days, half of the time he served in jail. The other half was suspended.
But he was also placed in 5 years of probation and 5 years on an alcohol monitor.
But he could have done the whole 60 days and there would have been nothing then. He couldn't even have done the 5 years, but it would have been over.
It's true. It's true, Your Honor. We're appealing what was provided to us by the court. Do I have any time left?
You do, you have about 3.5 minutes. You
I'll
want to
reserve
reserve
that.
or continue?
I'm sorry, I'll reserve it, Your Honor.
Okay.
Thank you.
May it please the court, my name is Frank Carlson. I was the prosecutor involved in this case at the time. I'm no longer the prosecutor for the city of Amherst, but I am the assistant law director. So I'm obviously well acquainted with the case and with the facts and the procedural history of the case. And I would just submit to the court that what we see before us is an exercise of discretion by the trial court in trying to arrive at a sentence which is sensible and meaningful to the defendant. Regardless of what the original charge was, he was convicted of a third-degree misdemeanor. The court was aware of his prior record, and what did the court do? I think that the sentence can be seen as an effort on the part of the court to deter, certainly, the defendant from this kind of conduct in the future, and particularly offenses that relate to the consumption of alcohol. So if that's his goal, is to somehow stop the defendant from doing those things that he had done in the past, what is a reasonable way to do that? A reasonable way to do it, as I think we all know as parents and legal practitioners, is to say, okay, we're going to give you some punishment. And what is the purpose of punishment is to deter. The purpose of punishment is to cause the defendant to reflect on what he has done. So, and also I would submit that a purpose of punishment is expiation, in a sense that this defendant could say, I've done something wrong and I've paid a penalty for it, and I'm therefore somehow right again with the world or with the justice system, if you follow that. So the punishment serves that kind of salutary purpose. It's not just to extract some kind of mean consequence to the defendant. And then sensibly what the judge did is say, in addition to that, I'm going to reserve some time over your head. And why am I doing that? Well, the court's doing it for a number of reasons. The court wants to retain some authority over this defendant. As Judge Schaefer has noted, he could have said, I'm going to give you 60 days in jail. And then the defendant does 60 days in jail and he's done. The judge doesn't like that. I wouldn't like it either. The judge wants to say, I want to have, a string on you. I want to be able to monitor you for a period of time. I want to make sure that you're making the right kinds of decisions. So the judge does what you might expect. He's going to say, I'm going to suspend 30 of these days on conditions. The 5-year period of monitored time, I think, is only sensible in this circumstance given the defendant's history of alcohol-related offenses. So I think what we all know is that alcoholism is an intractable disease, that the longer that we can put ourselves in a position to monitor somebody's behavior in that respect is a good thing. And finally, the idea of the alcohol monitor being somehow cruel and unusual, probably that's not the right term, or an abuse of discretion, I think is way wide of the mark. Because of those of us who have practiced in the municipal courts, I think we understand that the alcohol monitor is an extremely effective tool for controlling somebody's behavior. And I think I fairly characterized the alcohol monitor in my brief as the defendant's lifeline. So rather than seeing this as a cruel punishment, I think the defendant ought to understand that what the judge is trying to do is help Mr. Carney, help him to avoid those things that he's done in the past, help him to straighten his life out, and give him a period of prolonged sobriety as a result. I've also noted in my brief that the court retains a jurisdiction if it felt that Mr. Carney was well on his way to a more permanent recovery than he exhibited in the past, that it could say, okay, Mr. Carney, you can take the monitor off. But to say that now that's an abuse of discretion, I think is way wide of the mark. If we were to say here today that this constitutes an abuse of discretion, what are we telling trial judges who I think genuinely try to make decisions that are meaningful and sensible? And this, I see, is certainly one of those. A couple of things have been mentioned about the length of the sentencing entry, and again, Judge Schaefer, I think, noted that this was a defendant who had been in the news about this. There was press coverage. The judge certainly knew that his opinion would be scrutinized by the press, and is making an effort, I think, to fully explain to the public, what goes into a decision like this, and it is commendable that he did so. To say that he shouldn't have done it, or that he has to do it in every case, is somehow not a good thought, I think. The cases that were cited to indicate that maybe there was a different kind of approach to this defendant than this judge has employed in other cases, there's not a sufficient record for that. What you really need to do is to pull out those cases that involve a defendant who has had a history of alcohol offenses and who has come back repeatedly to the court, and see what Judge Giannuzzi has done with those cases. And I can't say, I can tell you what he's done to those cases, but there's nothing in the record to suggest that he has done anything differently in this case than he has done in cases that are similar. So what we haven't been provided is this kind of apples to apples information that we need to make that kind of a judgment. Your Honor, I practiced in that court for 8 years. I know how Judge Giannuzzi operates. The idea that he doesn't listen at sentencing just because he comes out with a proposed entry is not the way it happens there. He's free to, and has done many times in the past, line through what he's brought on the bench because of information that's been provided to him at the time of sentencing, and he'll change the entry, he'll modify it. You know,
Well, unfortunately,
sorry.
we're not going to have any of that in the record.
Okay, yes, you're right, I'm sorry.
But to your point, my concern was that the appellant bringing in cases on the reply brief, that it did not give you the opportunity to respond. So,
I understand.
That's
Thank you.
measured about that.
Also, the suggestion that somehow Mr. Carney is entitled to a suspended sentence because he has done this and this and this, following the charges being brought, I think, again, is a little wide of the mark. The fact that he's shown kind of a jailhouse conversion to sobriety, not to be too cynical, but to be somewhat cynical, doesn't entitle him to any kind of sentence. That's what I had to say. Thank you. If you have any questions, I'm happy to try to answer them. Thank you very much.
Thank you, Kenneth.
Thank you, Your Honor. Thank you, Counsel. The journal entry reflects that the case was commenced on May 16, 2014. From 3 days later, he was placed on an alcohol monitor. He was on an alcohol monitor up to the date of sentencing, so approximately 5 months went by with no violations. That is also in the sentencing record. I don't believe in my arguments I use the word entitled, or as Mr. Carney said, he's entitled to anything. But what Mr. Carney believes is he was segregated and sentenced differently than other people are sentenced in the over the municipal court. And again, the 17-page journal entry is reflective of that. With regards to the court's option to lessen a community control sanction, Mr. Carney can't wait 1 year, file a motion, then ask that his sentence be commuted by the court or suspended. If the court denies it, he doesn't have a right to appeal, in my opinion, at that point.
What do you mean he doesn't have a right to make the motion?
He has a right to make the motion, but I don't think we have a right to appeal it. So he has to appeal it now, and we have to address this now with the 5 years of community control. I'm sorry, with 5 years of intensive probation. Part of his community control sanction in the 5 years of the alcohol monitor. Thank you for your time.
Thank you.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. We are adjourned.